Good morning. We're just wait for folks to arrive here. So happy you could be here with us.
Hi, good morning, everybody. Thank you so much for taking the time today to join Brandon and myself. We're really looking forward to this conversation we're going to have today.
Yeah, and I see folks are coming in, Nicole. So we can kind of just chat a little bit. I don't know if you want to introduce yourselves and kind of roll in a little bit. I know it's still kind of early, but yeah. Feel free.
Yeah, sure. That sounds great. So hi, everybody. My name is Nicole St. Germain. I'm the Lead Outreach and Education Coordinator for the United States Equal Employment Opportunity Commission. And we're going to spend some time today talking about the EEOC and who is covered, how you're going to file a charge. I've been with the agency for 12 years now, had the great pleasure of being in the role of doing outreach and education for over 5, which has given me the opportunity to meet Brandon. Brandon, you want to tell the people a little bit about yourself?
Well, good morning, everyone, and great to be here with you, Nicole. And yeah, I'm the Assistant Deputy Director of Education and Outreach for the California Department of Fair Employment and Housing. And I always say it's the longest title, I think I can say, but otherwise known as DFEH. And, I've been at the department now for over 2.5 years. And, I'm prior to that, I was, doing civil rights work and working as an attorney. It's really great to be here with Nicole, kind of, share this kind of civil rights, kind of like Justice League, so to speak, as we work together. And, my role, really at the agency is very similar to what Nicole's doing. Is really to provide this education, outreach, explain our laws. And, we thought it would be great to come together because we work closely together. Our agencies, have the same mission, and we really think it's just great to kind of connect with the public and kind of have a kind of basic know your rights session and give an overview of what we do.
Yeah, and we're really excited because Brandon and I had actually thought that we would start doing this on a monthly basis. And so this is the first in kind of a 4-month timeframe where we really just want to reach out and offer a free webinar to the community, to employers alike, to say, hey, these are some really interesting topics that we're seeing that people really want to know more information about. And so we're going to be offering this the second Tuesday of the month now through December. We're going to change the topic each month, so be on the lookout for more information and more flyers so that you can join us for the next sessions as well.
And before I forget, Nicole, we move on. Let me ask if I could, our interpreters this morning, our Spanish interpreters, both Sol or Ryan, to just give an announcement that we're going to enable the interpretation button on the bottom right-hand corner as soon as they give their announcement, and to be able to hear the interpreted version on the other line. It's all you, Ryan or Sol. Okay. Okay. Not hearing them. Let me just.
Is interpretation just enabled at the bottom?
Yeah, let's see what happened. Let's see, update. It was here. We tested it just momentarily. Let me try to end it and start it one more time.
It's working
yes,
just
hello.
fine, Brandon.
Oh, there we go.
Hello, everyone. Yeah, we can't speak to the general audience, Brandon, when we're in the interpreter's booth. So, but the interpretation is available, and I'd be happy to interpret that for our Spanish speakers. Si desean optar por el idioma español durante la conferencia, por favor hagan clic en el icono del globo en la parte inferior de la pantalla y ahí pueden seleccionar el idioma preferido.
Thank you so much, and I'll go ahead and start. I appreciate that. Thank you.
All right,
okay.
So anybody who needs interpretation, button down at the bottom there, please feel comfortable with the screen, find the chat box. Really appreciate everybody already introducing themselves in the chat box. As I said, we really want to have a conversation today. Brandon and I are looking forward to answering some questions that you have. So drop those in the Q&A box. We're going to save some time at the end so we can get into some questions. And we do want to give a big shout out to Alex, who is in the background, who's going to be monitoring both our chat and our Q&A box while Brandon and I are chatting this morning.
Yes, and also too for folks, there is the live transcript button you should see at the bottom if you want to follow along with the closed captioning. So yeah, well, I think we did all of the like housekeeping and kind of the updates. But yeah, we're ready to get it started. Should I go ahead and we have a few like a couple of little slides to talk about and kind of base our conversation over this morning. I can go ahead and just pull it up for get it up for everyone and get our conversation started. Here we go. Okay, 1 second. Okay, that's showing up?
There we go. You got it.
Yep, okay, excellent. Always you think after the pandemic and all this, there's still some Zoom anxiety moments we have, so I'm glad it's working, just me. Oh, there's always something, but yeah, so we did our welcome, and there's our information. We have our contact information at the end, so if you miss it, feel free. But yeah, I mean, I guess we could kind of start here, like,
Yeah.
who are we? Yeah, take it away.
Yeah, so really we just want to say that, EEOC is an independent regulatory commission. We're the federal government, and we enforce federal anti-discrimination laws in employment. So we were born out of the Civil Rights Act that was signed by President Johnson back on July 2nd, 1964. We opened our doors exactly 1 year later on July 2nd, 1965. We are headquartered really in DC, which is where all federal agencies are headquartered, but we've got 15 district offices throughout the country, 53 field offices, and I am part of the Los Angeles district office, which covers central to Southern California, all the way to the border with Mexico, all the way east to Nevada and Arizona. We cover central and southern Nevada. We also cover Hawaii, Guam, American Samoa, Wake Island, and the Commonwealth of the North Mariana Islands as well. So we have a very large territory with a huge demographic of individuals involved.
And what Nicole is not saying too is that her jurisdiction allows her pre-pandemic would have to do trainings and travel to Hawaii and some of the beautiful places throughout our region. So yeah, so it'd be very similarly the Department of Fair Employment and Housing, DFEH. We are a state agency. We're part of the state government, and we have a similar, civil rights mission as EEOC. Similar idea kind of being born out of the civil rights movement and becoming kind of the embodiment of, government trying to prevent discrimination. But with DFEH, not only do we do employment discrimination, which is one of our kind of major areas of focus, but we also have jurisdiction. We'll talk more, but we enforce housing, fair housing laws, as well as laws around public accommodations and others. But we work very closely with the EEOC and have a kind of shared mission. But yeah, we do have these different laws we enforce, but they are very similar, and there are little kind of tweaks to them, but they really all go to the same mission of civil rights work.
Yeah, it's the same heart that's there that we're looking for, is to eradicate workplace discrimination. For the EEOC, California is looking to eradicate discrimination not only at work, but also in housing and public accommodations. So DFEH has that more expansive than the EEOC. EEOC is very specific and only looking at workplace discrimination and harassment.
Right. That's a key point. I'll go to the next slide here just to take us there. Yeah, well, this kind of is a really good follow-up point, because now we can kind of get into like, what are the laws that each agency enforces, and tell us about all the work the EEOC is doing and all the various laws.
Absolutely. So EEOC is in charge with enforcing Title VII of the Civil Rights Act, which says that people can't be discriminated against because of their race, their color, their gender, their national origin, their religion. And then back in 2020 of last year, so I guess not back, but just 2020 of last year, we've expanded the understanding of what that law says, so that when they talk about you can't discriminate against an individual because of sex, it's also including individuals who are LGBT as well. And that case came out of the Supreme Court in the Bostock decision. We also enforce Equal Pay Act, which says men and women cannot be paid differently for the same or similar work. Age Discrimination and Employment Act, which says it's illegal to discriminate against individuals who are over the age of 40. The Rehabilitation Act of 73, which was the federal government's precursor to the Americans with Disabilities Act that came out in 1990. I don't want to miss the Title I of the Civil Rights Act of 91, which actually gives the EEOC the opportunity to obtain monetary relief in court from individuals who have been for individuals who've been victims of discrimination in the workplace. I touched on the Americans with Disabilities Act back in 1990 that said that it's illegal to discriminate against individuals with disabilities in the workplace. That law was then expanded by Congress under the ADA Amendments Act in 2008. There was concern that maybe some of the rulings under the ADA were just too narrow, and it wasn't really keeping with what Congress wanted the law to really provide. And so they very much expanded what a definition of a disability is, and really looking more at what an employer can do to provide an accommodation for an individual with a disability, and less of the onerous on that individual to prove they even had a disability. So we took the focus away from the person with the disability and put the focus on the employer. Could they actually provide an accommodation? Mm-hmm. And then in 2008, we also have the Genetic Information Non-Discrimination Act, which says it's illegal for an employer to take information that they may obtain about your genetics, which can include family medical history or genetics through DNA, and use that information to then make employment-based decisions. So if they find out you have a family medical history of heart disease, and then they're concerned that they don't want to promote you because maybe that could cause more stress, and you already have a history in your family of heart disease, they're then taking genetic information and using that to make a decision based on your employment there. And so that's illegal as well. So those are the laws the EEOC enforces. I can turn it on over to Brandon. Why don't you tell us about the laws that the state enforces?
Sure. Let's get into it. So very similarly, to Title VII, we have the Fair Employment and Housing Act, the FEHA, as it's often called, and it's really two parts, right? One part of the law really deals with employment discrimination, right? Very similar to the EEOC's Title VII protections. There are some little tweaks and differences, but broadly that's the law that protects folks from employment discrimination, the state law. And we also enforce the housing side of the FEHA, which prevents discrimination in housing, very similar to our federal Fair Housing Act, right? So you see the kind of interplay. Again, similarly, but a little bit different with the EEOC is we also enforce the Equal Pay Act, in California, which our friends over at the Labor Department also enforce here at the state side, the Department of Industrial Relations, but we also do as well. And again, employment discrimination can be very similar to discrimination in the Equal Pay Act, but in California, it also covers gender and race and ethnicity, so it's a little broader, the Equal Pay Act. But that's what prevents unequal pay for folks who are doing the same or substantially similar work based on their race, ethnicity, or gender. And then importantly, another law kind of on our different side of the jurisdiction head of DFEH is we enforce the UNRRA Civil Rights Act. Some people call it UNRRA Civil Rights Act, but I believe the correct pronunciation is UNRRA, named after Jesse Unruh, the state legislator, Civil Rights Act. And what this law is all about is this is the law that prevents discrimination at businesses, public places, going to a store, going to the movie theaters, so we have jurisdiction there on any kind of protected basis, and we'll talk about that. But if it was disability-based discrimination or race discrimination in a business, we have jurisdiction. Importantly, in California, DFEH enforces the Ralph Civil Rights Act, and unfortunately, over these last couple of years, the Ralph Civil Rights Act has come up more often due to the deplorable attacks on folks in California, throughout the country, on the basis of being an Asian American or a Pacific Islander. And the Ralph Civil Rights Act prevents against that. It prevents someone intimidating you as your person or your property on the basis of who you are, and also includes a $25,000 penalty as well. So it's an important law for that, for unfortunately what we've been seeing in the pandemic and the rise of hate. Disabled Persons Act is, won't spend a lot of time there, but, again, many of the protections for persons with disabilities in public places and access. Another one you may not know is we have jurisdiction under the Civil Code for the victims and survivors of human trafficking, both on the labor side for like forced labor trafficking, threatening someone with coercion and duress, and you're not going to pay them. So we have labor trafficking, as well as we have the sex trafficking side. We do the civil side. We're not doing criminal enforcement, but can obtain damages for those folks who have been victims and survivors. And then we also have funding under government code, or we also have a jurisdiction under government code 11135 that really prevents discrimination within anyone receiving state funding. So again, lots of law there, but certainly the Fair Employment and Housing Act is one of our biggest areas of jurisdiction. So yeah, let me throw it back to you, Nikki, now here to kind of walk through. We talked about, what we do and kind of what's covered. You want to take us through who's covered?
Yeah, and so this is kind of, the who's covered. So federal and state, we have a lot, as Brandon and I mentioned, a lot of the same similarities. So we cover individuals based on race, color, national origin or ethnicity, disability, religion, age. If you're over 40, there are no laws currently that protect individuals who are under 40 who may be experiencing age discrimination. Sex, which includes pregnancy, sexual orientation, transgender status, genetic information, and then we cover retaliation on all of these bases, which says that it is illegal for someone to retaliate against you because you are exercising your rights, whether you're reporting internally complaints of discrimination or harassment, or you're going externally to an agency like either EEOC or DFEH and reporting it, or maybe you're participating in an investigation internally or externally about discrimination or harassment. If you're associated with somebody, so if you're a family member of somebody who has participated in a discrimination or harassment complaint or investigation, and you are then being retaliated against, there are laws out there that really protect you from that. But the state of California has always been a little bit more progressive than maybe the federal government has. So they have some additional protections that we don't have here at the federal side. So they cover all of what we talked about that the federal covers, plus they have some additional protections. Brandon?
Yeah, great explanation, and I'm really happy you hit retaliation, because it's such an important part of what we're saying, that you can't be retaliated against for exercising these rights. But yeah, as Nicole said, very similar, a few little differences. One of them, is around race. We definitely, both sides prevent against race discrimination. But in 2020, our FEHA, our employment law, was amended to now include hairstyles and hair textures historically associated with race, because there was kind of it wasn't really a good ruling out there on the law, covering folks with cornrows or dreadlocks or braids or twists, and folks were experiencing, especially Black women, were experiencing discrimination in the workplace. Now that's considered race discrimination, right? And it's not just like on the, I think, Title VII side, where an afro had always been covered, and that's where this law needed to come, because the other hairstyles historically associated race were not kind of covered, and we had a difficult state decision that came down years ago. And luckily now it's clarified in law. That is race discrimination. And then we have ancestry, which is very similar to like national origin. So you can kind of think of that similarly in terms of where you're from, your country of origin, your ancestors. Medical condition. Again, comes up in a lot of similarities, but it's kind of a very narrow area, kind of related around a cancer diagnosis condition. And then we have marital status. Again, treating someone differently because they are, example, unmarried or a single mom, and they're going to face discrimination. And then we do have a specific protection for military and veteran status in California. So, and again, many of these can come up in different ways or different forms, but this is a broad kind of just takeaway of who's protected. And, we all are protected from discrimination. I think that's, everyone should know that we're all protected, and these are the bases of protection.
And so even though like the federal side doesn't have like a Crown Act right now, that doesn't mean that we haven't found violations based upon hair texture and style. We recently resolved a case publicly out of Las Vegas in which a woman wasn't selected for a position with a security company because she had her hair in braids and because they didn't feel that that was a professional style. Like that's what they told her, but without even interviewing her. If she wouldn't change her hair, they weren't going to even allow her to have an interview. And so we found that violation as a violation under race, but California has that more kind of expansive look at having the Crown Act, where we're looking at situations like that and saying, okay, well, it is because of race that this person is being treated differently.
It's so fascinating because this issue came up. The issue of hairstyle and hair textures being race discrimination came up years ago, and we used to have a commission at the department who would hear cases. We don't have that anymore, but there was a case came down with a retailer of clothing who fired a black man who had put his hair into braids to celebrate a college graduation. It was like graduation was on the weekend, and part of the family tradition put his hair in braids to celebrate. And was told that it didn't meet company policy. They had a quote unquote Southern California surfing image, and that didn't meet up with it, and they was subsequently terminated for not putting his hairstyle. And then when the commission heard the case, and this was years ago, it really made this distinction between quote unquote natural hair, like an afro, which would be race discrimination, and then said, oh, but if you put your hair in the braids or twist, it's quote unquote unnatural, therefore it's not. And that bad case was out there, and it created this kind of area where it wasn't clear. And so thankfully now that isn't the case, and that would be race discrimination. But yeah, and you're so right, Nicole, that so many of these issues have been kind of if it was it falls under race discrimination. Everyone should know that if you feel you're a victim of discrimination, you go ahead and file that. You don't have to do all the gymnastics sometimes of the law. And that's just one thing to let you know that both of our agencies, we do that investigation. You give us the the evidence and the information. But yeah, that's great. Anything else you want to say about this slide?
No, just retaliation, guys. We see it all of the time. I mean, more than 50% of the charges filed with the EEOC nationally allege retaliation. And it is just at 50% in the state of California alleging retaliation. It's just something that comes up quite often. And both of us our agencies have a very strong stance against it because it can just chill other people from coming forward and reporting any type of incidents in the workplace. So if they see something bad happen to one of their coworkers who reported an incident, they're not going to go forward and report something. And so just be mindful that if retaliation is occurring, we see it often, and we want you to feel comfortable coming forward and reporting it.
That's right. And that's even, doesn't matter what happens with the underlying claim too, even if it turns out that, HR, whoever finds that it's not, or, you're still protected, even if you're not able to prove race discrimination occurred. They still can't retaliate against you. It's not dependent on, oh, I proved this, so therefore I'm protected. Now, I know you're protected because you filed that complaint or you're in an investigation. And let me just ask this. I know with us at the state for employment discrimination, disability is, one of our highest areas of discrimination we receive. In some years it's age, but, last year's been disability. On the federal side, is it similar?
It is. So federally, disability is second to retaliation, and then race is actually right after that.
Okay.
And they're right about 34% and 32%.
Okay.
So yeah, disability is the number one thing nationally, and it's also the second, or not the number one thing. It's the second thing nationally. It's the second thing in the state of California as well.
Yeah. And it's generally, I always, the borders really often don't distinguish between the national trends often. What you see at the state and what you see nationally are happening. It's not, oh, it's not happening here. It's happening everywhere, and you see that those things are very similar. So we talked about the kind of what's protected and who's covered, but all right, well, we can get to that. Who's protected under our laws? You want to take it away?
Yeah, sure. So for the federal laws, so employees are protected, temporary workers, job applicants, so if you're applying for a position or you are a former employee, you're protected as well. We protect undocumented workers. We do not ask about documentation status. We've got court precedents that says we don't need to ask about documentation status. The EEOC is concerned with whether or not the employer is violating the law. And if you have employers that are looking to violate the law, they sometimes are going to target individuals who are more vulnerable and the people they could exploit, which at times is going to be your undocumented worker, maybe your worker who doesn't have a good command of the English language, might be a little bit more fearful, somebody that they can then threaten. If they don't do what they want to do, they can threaten them with deportation. We've seen that. And so because of that, we want to make sure those employers are held accountable for how they are treating those vulnerable individuals. Therefore, we don't ask about documentation status, and we cover individuals who are undocumented. It's how we also have covered individuals who've been trafficked into the country for labor trafficking. You know, there's situations where individuals may be brought here by a contractor and sent to different locations for forced labor. And we've been able to find resolutions for those individuals as well. On the civil side, once again, as Brandon mentioned, we're talking civil. Sometimes the criminal side can't finish, can't find all the evidence necessary to get to that beyond a reasonable doubt. But on the civil side, we're looking at just a preponderance of evidence, and we have a different standard there. And so because we don't care about documentation status, and we're really looking for employers that are just capitalizing on individuals who may be vulnerable, we want to make sure that we are targeting and fixing those types of situations. We do not cover independent contractors. However, there have been times where an employer will label an individual an independent contractor, and they're kind of not.
Right.
So we do an analysis to determine whether or not somebody really is an independent contractor. So if you don't know whether you're an independent contractor or you're questioning it, we're always going to say, please come and talk to us. We would rather have a conversation with you, go through an analysis to determine if you really are, versus just not going forward and filing a report or a complaint. We also don't cover interns or volunteers. For us, it's really looking at somebody who is being paid by the employer. And I know that's a little bit different on your side, right, Brandon? The state has a little bit more expansive coverage for who's protected.
Yeah, I mean, so we do have, again, a lot of similarities, and of course, this is just our who's protected, under our employment laws, right? Under our other laws I talked about, housing, and we have a whole thing there. But in employment, yeah, very similar. But we do have some differences here. One of them being, the unpaid intern and volunteer are protected against discrimination and harassment, which is an important distinction that comes up and may mean where a case would go. And then on the independent contractor side for harassment, if you're providing services pursuant to a contract, right, you're protected from harassment in the workplace, right? If you're a contractor providing, example, janitorial services, you're a contractor doing services for someone, protected against discrimination from that person who's hired you, the employer. Things can happen. So that is an important distinction for the harassment side, that contractors are protected in that situation from harassment. But broadly, most forms of the workforce, more or less, and folks are protected either under our federal or state law. So just again, know that as you're educating your community, or if it's educating yourself, that broadly, folks are going to be protected. And we kind of go through and do the classifications and what, but you're protected from employment discrimination, and just everyone is. Trying to think anything else to really say on that. I mean, I think that's a good point. I can go to our next. Anything you want to add?
No, I mean, I think we covered it all. I like the point that you're just stressing, that you're protected. That's one of the things we really want to stress throughout this entire presentation, is based upon the categories that are protected, you're protected. Who's protected? Everybody that has something to do with employment is going to find some form of protection at either the federal or the state level.
And we, both agencies have, great staff who, work incredibly hard to do this investigation work and do the questioning and help sort it out when you're calling. Because usually, I would say we're one of the, EEOC and DFEH are kind of agencies that you don't need until you need. until it happens. You weren't thinking about us until discrimination occurred, and usually it's at a difficult time, and it can be traumatic. And we are we have a lot of folks here who help sort that out. Our investigators for each agency. Yeah, you want to talk about who
Sure.
the charges can be filed against?
Yeah, so you're going to find, once again, very similar type of things here. Who can charges be filed against? You can file against employers. So EEOC covers both private and public employers. I will say EEOC is an independent agency because not only are we tasked with investigating and enforcing discrimination in employment laws for private and public sector employers, but we're also tasked with doing that for the federal government. So even if you are a federal employee, don't think that you're not covered. We are the agency that you can turn to after completing your own internal complaint to review that. But for private and public sector, we're talking, your Lowe's, your Walmart, your mom and pop donut shop, whatever it is. Plus, you can also have public. So your state, local governments, your schools, your universities, all of those are within the public sector. So we cover those employers. We cover employment agencies. So if somebody's being a placement agency, joint employer issues, anytime we file against like a staffing agency, we're also going to file against the employer because we need to determine where the discrimination happened, who knew about it, who was aware of it, who allowed it to go on. And sometimes we resolve for both parties. When we have done our human trafficking cases that have come in, we file against the contractor that brought them in, and we file against the placement where they were working. When we do farm workers, we often have a farm labor contractor who will place individuals on farms. And so those are considered employment type agencies. We've seen everything from employment agencies who have made little marks on applications to write about somebody's, what they look like, what their age is, what their race is, so who they're going to send. And so sometimes you'll have funneling of only people of color are going to one job and only men are going to another job. And so there's this segregation that we've seen through employment agencies. Sometimes the employment agencies say, hey, it's not on me. It's the company that we've contracted with. They're telling us that we want these certain individuals. So then that's where we have to file against both parties so we can determine what's happening. We also cover unions for some really specific things having to do with employment. So if you're classifying or segregating or limiting your membership, and the membership is what gets you into different types of employment, referrals for individuals with membership, or even referrals out for employment. There's a lot of positions, particularly here in LA, whether you're in the industry, like the entertainment industry, or even if you're working, in the ports, it requires you to be a member of the union before you can even be placed out for a job. And so if there's segregation, if there's discrimination within the unions, then it's impacting somebody's ability to have that equal opportunity within employment.
Well, that's a great overview, Nicole. I mean, and similarly with DFEH, on the employment side, I mean, I think one of the, interesting distinctions, is that, under our Fair Employment and Housing Act, under California law, the anti-discrimination employment law, it applies to all employers, definitely, public employers, whether it's small Mayberry or, government, whoever, they're covered, as well as, private employers who have 5 or more employees. So it's kind of a low number of folks, who are going to be covered under the FEHA. So it does apply to most employers, but our anti-harassment laws apply to all employers, even less than 5, right? So it applies to an employer of 1, cannot harass someone, but that employment discrimination kind of, paradigm similar to EEOC applies for us at 5 or more employees. And, those are really, a couple of the major distinctions. I'll just say I did bring it up, but just because it's interesting and relevant here, that we also have jurisdiction under the Civil Code to prevent discrimination, kind of against kind of the non-traditional business relationships, under the Civil Code, where it could be like a real estate agent or someone in a non-traditional business setting who's harassing someone and there could be kind of like quid pro quo harassment. It's not a normal employee-employee relationship, but it's like, hey, I'm a realtor and we have a business relationship where, I give you, referrals and things, and then I'm harassing you in that context. We also have jurisdiction there. We've been able to do that in a few different cases where those kind of non-traditional employment relationships where there's harassment. So broadly, on the employment side, kind of, applies to most folks, 5 or more. And then we have that protection against anti-harassment to 1. So whether it's an EEOC or a DFEH, generally, folks are going to be protected under this kind of umbrella of civil rights laws, which is a really good thing.
That's a really good point that you brought up, the number of individuals that need to be in employment. And I know we got a little bit later on in the slides, but let's just talk about it here. So for EEOC, the majority of our laws require the employer to have 15 or more employees to be covered, unless it's under the Age Act, in which it's 20 or more employees, or Equal Pay Act, in which it only needs to be 1 employee for us to have coverage. So there is a distinction. Smaller employers are covered more under California Department of Fair Employment and Housing than they are under EEOC. So it's really great that here in the state of California, we have 2 agencies that can still provide service, even if one may not be able to, just upon like the number of people that are being employed. So that's a really good benefit between having both of our agencies available in the state.
Yes, and it's like I always say, we work for you, and that's what's great is, both agencies provide this umbrella coverage, so everyone's protected, and we'll help you get to the right place, and either way. So yeah, and on that point, let me go to this point, Nicole, about just we kind of hit a little bit of it, but yeah, talk about just a little bit on the jurisdiction.
Sure. So jurisdiction. So we look at like who can file a charge with the federal government and individuals. So most of the people that most of the charges we get are filed by individuals. They come forward and report to us. Like we have the ability for people to just call. You can go to the website. Not during pandemic times. You could just walk into our office and talk to somebody about whatever's happening in your workplace. You can have people file on your behalf. So if something happens and you are young, you're maybe not an adult at this point in time, but you're working, you're also vulnerable because you don't know what's allowed or not allowed. And some people take advantage of that. A parent or a guardian can file on your behalf. We've had situations where individuals had their family members continue a case for them after they've passed away. And so we have things like that. We also have the ability as an agency to file a charge from our commissioners. So they review information that we may have received either anonymously or we have found out through the course of just day-to-day lives. We had an entire commissioner's charge come out of our agency as a result of an NPR podcast in which people were talking about a situation, and it got our little light bulb going, and we said, oh, let's take a look at this. And once we started just doing a cursory exploration into the employer, we were finding all of these violations. And so we were able to file a commissioner's charge in that case. We also have the right to file a directed charge locally with our directors. And those types of cases can be filed under both age and equal pay, where it doesn't have to go to the commissioners in headquarters in DC, but it can be filed by our director here locally. We already went over the number of employees. The next really important thing to think about is how long you have to file a complaint. And for us, it's going to be 300 days. So 300 days from the last date of violation. So from the time that you were put on a performance improvement plan, or the time you were not hired, or the time that you were discharged, 300 days, roughly 10 months from that date is how long you have to file with the federal government. And that's going to be a little bit different than the state, right, Brandon?
Right. So it's interesting. We've had a change in the law here over the last couple of years. If you weren't following the breaking news of employment law, but right now in California, you have 3 years to file a complaint of employment discrimination. So it's 3 years. It has changed. This was because in the wake of the Me Too movement, and I think just broad awakening that a lot of folks weren't able to make it within the time frame of what used to be 1 year, and people due to trauma, due to a lot of issues, and there are ways the timeline can be moved through the law sometimes, in terms of that continuing harm. But broadly, everyone should know that you have 3 years to file a complaint. and that is a change. So again, between both agencies, this kind of broad umbrella of protection that can apply to you. And similarly to the EEOC, we talked about who can file the charge, but here at DFH, we do have something called a director's complaint, where our director, Kevin Kish, can bring a complaint in the name of DFEH against an employer for a more systemic type of discrimination, broad impact case, which we have exercised very recently. And so this is another way that our agencies protect the public, where there can be those difficult cases where there may not be a complainant, or there may be great fear, and there's an opportunity for a director's complaint who can really help. So broadly, we have this kind of umbrella civil rights coverage, and both doing very similar work, and unfortunately, there's a lot of work to do, and the complaints do keep rising, and I think it's a level of more awareness of laws, as well as there's still discrimination occurring in the employment side. So all the reason why it's important to get into this.
Yeah, and I think it's really important that we highlight that time frame difference, because for the EEOC, we have no wiggle room. So if you come to us at 301, right, 300 days and one, and the reason you came to us then is because you just didn't know about us. Like, that's the role of Brandon and I, is to make sure that individuals know who the EEOC is, who DFEH is, what their rights are, and how they're protected. If you didn't know, and as Brandon said earlier, you don't need us until you need us. Unfortunately for us, it's the law that has given us this very strict time frame. We don't have any wiggle room on it. So it's really great to know that, once again, kind of in this partnership between the federal and the state side, if you didn't make the time frame on the federal side, you still have that opportunity to go to the state and to file a claim with the state, because they have more of an expansive time frame coverage.
Yeah.
On the flip side, coverage, EEOC has broader coverage because we are national. So we cover, like, physical distance wise, not only things that happen in the state of California or in the United States, but any of the US territories as well. So we do have broader reach in that sense. So if you're an individual who is working remotely and you're in California, but your employer's in Rhode Island, you can file with us, because we have that jurisdiction across the entire United States, being a federal agency.
Yeah, no, that's a great point. And things have changed, right, in the pandemic, looking at jurisdiction and what's happening. But yeah, generally, for DFEH, it's generally it happened in California, or you're working in California. The law has with pandemics is very made things interesting as to where people are working and what the law is. But that's one interesting thing. Like, for instance, some of our healthcare laws, that give people, new parents, the right to take time off and things like this. You have folks who are actually working in California. This is now their physical place of work. They're working here, and the California laws apply. And sometimes, like with harassment, even if the harassment was ratified by people in the state of California, things like that, there can still be some kind of a jurisdictional pool. But broadly, it's California. But there are those cases where there can be sometimes some exceptions to it, around harassment, or where it's been ratified by someone else, where it may have happened outside of California, but there's still going to be jurisdiction within California law because of that. But those are narrow. But broadly, you're protected anywhere. EEOC in California. We got you covered, unless you're like on SpaceX somewhere high in the air. So yeah. So let me go to the next slide. Let me just enable here. So yeah, you want to talk about some of the potential issues and/or some cases?
Potential issues, we really do cover every single possible thing that happens within employment. So everything from, we've talked about just those basic hiring, firing, layoffs, recalls, promotions, those things that you would think of. But then we also look at accommodations for both disability or religious. So your employer has an obligation to give you an accommodation for your disability, absent undue hardship, for your religion, absent de minimis hardship. It's how a job is recruited and where job ads are placed. Are you segregated? Is your work segregated? Are you assigned only one route? The type of training. Benefits covers everything. If we think about compensation as a whole, compensation and equal pay isn't just about what my paycheck says, like how much I'm getting paid per hour, but it really thinks about all the other benefits that you get within the workplace, from time off to retirement to anything like that, commission-based, all of that. Harassment, we cover harassment on everything. Harassment is definitely a big thing that is still obviously happening with the pandemic. We've seen a rise of it with kind of the racial justice reckoning that we've seen over the past year. Since the murder of George Floyd, we've seen a rise in that. It's just a very, that harassment level, people are seeming to be slightly more comfortable in saying things that they may not have said beforehand. Yeah. And so they're acting out in ways, and they're thinking that they may not be held accountable. And we're seeing things just kind of in the public sphere where people are being held accountable in the public realm, not even just at the workplace. But we really want to point out that we cover all of these potential issues within employment.
Yeah, and you know, such a great point too, talking about harassment on all protected, you know, classes, and just to know it's not only gender or sex-based harassment, but it is, you know, very broad, you know, with everyone being protected. So yeah, I mean, and I would just throw out like one more potential issue, and kind of again to highlight what we're going to talk about at our next Know Your Rights training, and it will be, you know, another subject. But you know, one of the things we didn't get into too much is California's Fair Chance Act, which kind of provides specific rules around you know, hiring folks who've been formerly incarcerated, and you know, there's a whole section on that. We're going to get into that next you know, session, so stay tuned. But just want to say that's one more of the potential issues are, and I know on the EEOC side there's you know similar ideas, so we're going to talk about that. But yeah, I mean, you pretty much you know have it here. All these issues come up. They're coming up, you know, in various ways, different types of protected bases kind of trigger them. Certainly, disability is one that's, you know, quite frequent. But all of these are issues that we see, you know, on the various protected bases all the time.
Absolutely.
Absolutely. And I know, gosh, it's like time is flying. It's already we got like.
I know, it's almost time to like we got to get into
some
questions here. We haven't even done our complaint process.
I know. We'll do this and then we'll do questions. We'll go quick. Okay.
So our complaint process for the EEOC. Before pandemic, you could have walked in, but now everything is really being done online. So you can go to our website, www.eeoc.gov, to complete the online intake process. And then from there, you'd be scheduled with an intake interview. Cases out of intake can go through our mediation department, which is free of charge, where we have licensed certified mediators to try and resolve the complaint before it gets to investigations. Completely voluntary process. Both parties have to agree to that. Investigations, where we have investigators that will look into the case and determine whether or not there's a preponderance of evidence to support a violation of federal law. If we do find that, then we make a determination and we attempt to resolve the complaint over through our conciliation, which is just a very structured settlement. If we cannot resolve a finding, we then have the opportunity to do possible civil litigation through our litigation department. All of this is free of charge. If for some reason we do not reach the level that we can find a violation, we didn't get to that preponderance of evidence, we still protect the rights of the individuals that have come forward to file by giving them the opportunity to file a civil suit on their own in court. And we actually have an agreement with the California Department of Fair Employment and Housing that when you come and file with the EEOC, we dual file and protect your rights at the state level by giving you a state right to sue. So you would have that opportunity to pursue your claim in either state or federal court. Yeah, Brandon would take it over for the DFEH side. That's the quickest down and dirty of the whole EEOC process. Yeah, I think I've ever done.
I know, and this is going to be very, very similar, kind of quick, but same kind of idea that we have 5 offices throughout California, in Los Angeles, Fremont, Bakersfield, Fresno. We actually, opening an office in Riverside. So we are, out there for folks to access. You can file your complaint. And I forgot our Elk Grove office, our headquarters, excuse me, are in Sacramento area. So we have our offices available. You can file a complaint online through our CCRS system or Cal Civil Rights system. You can call us. You can email us. I mean, we can do it any which way to help you get your complaint in. We have forms in every language to help you. We have ability to serve anyone on any language if you call, and similar with the EEOC. So get your complaint in, and again, similar idea of you'll get an interview, and if your complaint is accepted, meaning we have jurisdiction, you've said that you were discriminated against on a protected basis and it's within our time frame, complaint will be accepted, and that it'll be served on the employer. And at that point, there's really been no investigation. It's just been, this has been intake of jurisdiction, goes to the employer, and then similar to EEOC, there'll be these mediation conciliation efforts with our DFEH mediators who do a wonderful job and do a lot. It's also great for the public. It's a way to resolve a case before it could take some time, a year.
Absolutely.
And you can, and then at that point, there's an investigation, occurs if we can't resolve it via voluntary conciliation, mediation early, right? So if both sides don't agree, similar, it doesn't happen, then a investigation is made, a determination is made that there's reasonable cause or not. And if there's not, as Nicole pointed out, there'll be a right to sue letter issued to still allow you to go to civil court and file. And if we do cause the case, there can be civil litigation, but there's a chance before we file a lawsuit for mandatory mediation. So that's one where it has to occur via court order. But if it doesn't resolve, then a lawsuit could be filed. So that's kind of the long story of it. And we both our agencies have resources and flow sheets if you have more information on like how it works and timeframes. So I would encourage
arrows that go every which way to kind of give you how it would run.
Yes.
There are a little bit differences. I know Brandon and I were just talking about it before we even came on. An investigation has to be completed under DFEH in 1 year, right? Whereas for EEOC, we have a longer time frame. So if the case is larger, if it's more systemic, if we're going national, if we're interviewing hundreds and hundreds of people, we don't have to have it turned around in such a quick time frame that DFEH has to have it turned around in. So there's some differences even when we get into the investigations. Like Brandon said, if there's a determination made, DFEH can require mandatory mediation. Our conciliation efforts over on EEOC, so say we made a finding of a violation, the conciliation efforts are actually still voluntarily. We want you to come and see if we can resolve this before it can possibly go to litigation, but even then it's still a voluntary process. Yeah.
And you're right. There's so much kind of back and forth. I'll just mention, like with a group case, that's the one time we do get longer to investigate and get a next year where it's a group case. Lots of people are impacted, but yeah, we don't have, that's what's great when we can waive a case to EEOC where time is running out and they have jurisdiction to move the case on a longer time frame. But again, that's that umbrella idea of we're working together to further civil rights. We don't want to leave anyone behind. So I guess with that, here's our contact information, and we have a few minutes to take some questions. I see there's a couple of questions in the Q&A, and Alex, you could serve up any stuff on the chat. I'll see what we can answer here.
Yeah, Brennan. So those first two questions are about this, about the same issue, but they came up after you had kind of addressed this. So maybe people want a little more clarification. Additionally, if you could speak on sending out the PowerPoint, because we've gotten a lot of questions on that. And then there was another question on if you guys could again explain jurisdiction, particularly around the Family and Medical Leave Act.
Yeah, sure, absolutely. So Brandon has the PowerPoint. I have no problem sharing the PowerPoint afterwards with people if you're okay with that too, Brandon. Because you registered, we'll have your email addresses and we'll be able to share that PowerPoint to the attendees in our presentation today. For FMLA, so not the right agency to talk about FMLA. So EEOC does not enforce Family Medical Leave Act, which is a federal law. It's actually the Department of Labor that enforces that. But the California Department, California has something similar. You want to talk about what California's
Yeah.
law is, and then we can talk about some of the differences with FMLA and California's law. But just know that I'm actually not the agency that enforces FMLA. I just, because of the work we do, obviously with our DOL partners, know about it.
Yeah, and we could again go into a whole thing on the California Family Rights Act, and again, this is the law, that just a couple of things. I mean, it provides new parents, time to bond with the child via birth, adoption, fostering, as well as it also gives folks up to 12 weeks off for a serious health condition, and 12 weeks off on the parental leave side. So for this, in California, the law recently changed, and now this law, the California Family Rights Act, applies to employers of 5 or more again. So now we have kind of parity in like all the laws are 5. And so it used to be, similar to the FMLA, it was, you had to have, it applied to 50 employers of 50 or more within a 75-mile radius, which is still the federal law. But in California, we got rid of the mile radius. We said it's just 5 people and wherever they are, and that's the deal. So if you're an employer and you have 5 people and you have people working in California, the California Family Rights Act is the law that will apply to you. And that's why I was saying earlier, people working and all this all over the place, it's something to be aware of. A lot of people are thinking about that of, hey, what are the laws different if I've moved my whole staff to California and they're working from home out of California permanently. And that's that point again. So yeah, it's 5 employers of 5 or more on the state side.
What about how long do employees have to work at the company before they go in?
Yeah.
I know FMLA has very specific timeframes an employee has to work at. So what about the state?
That's similar. It's going to be the 1 year and 1,250 hours approach. So it's not automatic. The California Family Rights Act that when you started and you get it, you have to have put in that time, so to speak, of that 1,250 hours within a 12-month period. So yeah, but we could, and that's something too. If folks have interest, we can talk a little bit more about that.
Absolutely, and we can bring in our partners.
I
can bring in DOL. Brandon can bring in those that enforce that at the state level, and we can have a whole conversation. We can expand that to include workers' comp. And bring in Department of Industrial Relations. We can bring, it's just how the disability laws interplay with both FMLA plus workers' comp. We get so many questions all the time about that. So if that's something of interest to people, drop it in the chat and let us know, so that we can actually see about as we move forward. And you can drop anything in the chat. You're like, hey, I always wanted to know about this, or could you concentrate on, this part of harassment or direct threat about that? We want to create kind of just a free webinar series that's really going to start answering some of the questions that you have. But Brandon really answered those questions on what the federal side for FMLA requires. It still requires employers to have 50 or more employees. You have to be working there for a year, and then, or that 1,250 hours, and you have to have those employees within that 75-mile radius. The FMLA is unpaid. It is 12 weeks of unpaid leave that protects you from losing your job during that time frame for things like a medical necessity for, like, if you have birth or adoption, but then also if you are sick with a severe medical issue, or if you have a family member and you need to take time off for that. There are other laws that can come into play that may not be. So if I have a significant medical condition and I'm trying to take FMLA and I've exhausted my FMLA, but I still need more time, maybe my severe medical condition is now going to be a disability or a medical condition covered under the California laws. And now the employer can't just fall back on, oh, well, I gave FMLA, I'm done, that's all I needed to do. Now they need to actually go forward and go through kind of the disability interactive process, see whether or not they can provide an accommodation to the individual and provide them more leave. And so that's where kind of that interaction between all of those laws becomes really important for individuals to know, so you can be the one to be advocating for your rights in the workplace, but then also for employers to know, so that they're aware and make sure that they are actually following the law correctly.
Well, and on that point, just because there are so many interplay of laws, in terms of the California Family Rights Act, the CFRA, the CIFRA, I mentioned it now applies to employers of 5 or more, but we had another big change this last year where now the protected family relationships, where if one of your family members has a serious health condition, you're allowed to have that job protected 12 weeks off expanded. So now it's, to a child of any age, as opposed to just being a dependent child. It's thrown in, other protections. So, in terms of siblings are protected, grandparents are protected, and some of these are not protected under the FMLA. So there's that interplay again where for employers there may be protection under the California law that was not available under the FMLA, and then there could be a leave that's different. So you might have different kinds of leave. So I don't want to have everyone's head to spin, but just want to let you know that there it is important to follow this interplay, and we have resources to help you understand that because they are very close. But looking at the time, I realize it's 11 o'clock already, and I know we didn't get to everyone's question. We can try to respond.
You see, honestly, like everybody, like look on the screen, there's our contact information.
Yeah.
Feel free to reach out to us. Unfortunately, we didn't get, I know there was a really important question about threats of deportation. We want to be able to answer your questions. Unfortunately, we just have run out of time. Apparently, Brandon, we got a lot of information to share with people. We're gonna have to maybe make this an hour and a half. Who knows?
I know. Well, we really thank you for coming. We were just wanted to do this and thought it would be helpful for everyone. And we're going to continue to do this. And feel free to reach out. You have our information, and hopefully join us again next month.
October.
In October.
So second Tuesday in October. Look forward for a flyer coming for us. As Brandon mentioned, we're going to be talking about re-entry and employing individuals that have, convictions in their backgrounds.
Yep. Well, thank you so much, Nicole. Thank you so much, everyone out there.
Have a great one. Thank you.
Take care. Appreciate it. Thank you, interpreters. We appreciate you. Thank you.
Bye-bye.
Bye.